Generally speaking, there are two types of liens that occur in civil litigation. There is something called a writ of execution, and there is something called a writ of attachment. So if a plaintiff files a lawsuit, he can ask the court for something called a writ of attachment. And what this will do is prevent the defendant from selling his assets or getting rid of his real estate prior to the trial. So if you think about it, if somebody were being sued and there was a likelihood they were going to lose, they would most likely transfer all of their assets to their spouse, their relatives, their friends, whomever, so that they could get it back after all the dust settles from the litigation. So in order to get a writ of attachment, the plaintiff needs to show that he has a reasonable likelihood of succeeding at trial. So the writ of attachment is good for 6 years or until the case is dismissed against the defendant. Now, should a plaintiff go to trial and win, he will get something called a writ of execution. And this is essentially a formal lien that he could use to put on the defendant's assets in an effort to get the defendant to pay the judgment that's owed. Okay, and this also is good for 6 years, and it can be extended for another 6 years. The judgment itself would be good for 20 years. Okay, so two types of liens connected with civil litigation, but the most two common types of liens are the writ of execution and the writ of attachment.